My name is Haley Barnett, and I am a staff attorney in the Disaster and Hurricane Unit in the Lake Charles office of Acadiana Legal Service Corporation. And I'm going to be talking to you today about FEMA appeals, and a little bit later, I'm going to get into the CDC, Centers for Disease Control, eviction moratorium. Next slide, please, Ruby. Thank you. So a really common thread that we've seen in our office and that we just heard generally is that people are being denied FEMA assistance. So the first thing I want to say is if you are denied FEMA assistance, don't panic. You always have the right to appeal a FEMA decision. Whatever that decision is, you always are going to have the right to appeal it. So that's really, really important. Another really, really important thing is that you read your decision letter in full. Your decision letter is going to tell you why you were denied assistance, and it's going to provide a little bit of a guideline as to what you need to do in order to, figure out what you need to submit in order to appeal that denial. So some common reasons for denial include you cannot prove ownership of your home, you had homeowners or renters insurance, you reported no damage when you initially registered for FEMA assistance. I know that was tough, especially in Lake Charles with the back-to-back storms. A lot of people still were not back in their residence when Delta hit. So it was kind of hard to get an accurate assessment of the damage from the second storm. Your home is safe to occupy, or you indicated that you weren't willing to move while your damaged home was being repaired, which could make you ineligible for FEMA temporary rental assistance. Next slide, please. There we go. So the appeals process works a little bit like this. So you should submit your appeal letter within 60 days of FEMA's initial decision on your application. So whatever the date is on your initial decision letter, you have 60 days from that date to get your appeal in. If your 60-day deadline has passed, be sure to include in your appeal letter why the letter is late. A great example of this is, like I said, the two back-to-back storms kind of really threw people for a loop. And so a lot of people did end up missing that 60-day deadline. But as long as you have, a good reason, your appeal should be considered. Your letter should explain why you disagree with FEMA's decision and include supporting documents that would entitle you to more and or different assistance. Let's say you were denied for temporary rental assistance. You would need to submit your pre-disaster lease and your new post-disaster lease, as well as your pre-disaster bills and your post-disaster bills in order to show FEMA that you are entitled to temporary rental assistance. If you're trying to get more or different home repair assistance, you definitely want to get contractor estimates. Let's say the storm knocked out your HVAC system. You want to get an estimate from an HVAC repairer or a roofer on how much your system is going to cost to repair or replace, or same thing with your roof. If you're looking to be reimbursed for temporary lodging expenses, you want to submit receipts of hotel evacuation costs. The documentation is so important with FEMA. You always want to try and submit as much as you can, as much supporting evidence that you are entitled to different or more assistance. And another key thing is if you were denied for home repair assistance, you always want to go ahead and apply for an SBA loan. I know Ruby, I think the SBA seminar was yesterday, but you always do, after you're denied home repair assistance, go ahead and apply for an SBA loan. And if you're denied for an SBA loan, FEMA wants to see that as a part of your appeal as well. Next slide, please. So your appeal letter should be notarized before you send it, or else you want to include this sentence at the end of the letter. I declare under penalty of perjury that the foregoing information is true and correct, next to your printed name, signature, and date. You always want to include this sentence on your letter because if you are not truthful to FEMA, you could, you could face fines and penalties, and it's not good. So you always want to include that sentence or go to a notary. I find it's easier for people to just write that sentence and sign their name because you need to sign the appeal letter anyway. And then you also want to submit the cover sheet with the barcode that was enclosed in your initial FEMA decision letter along with the appeal letter. This is kind of an easy one for people to miss, but that cover sheet is really important because FEMA scans it and it basically gets uploaded as part of your FEMA file. So be sure that you keep that. Don't throw that barcode away. It's pretty hard to miss in your letter. And then each supporting document that you submit should have this information on it. Your name, the disaster number. I think for Laura, it was 4559, and for Delta, it was 4570. Your FEMA registration number, which is going to be 9 digits, and the last 4 digits of your social security number. These 4 pieces of information need to be on every single piece of paper that you submit along with your appeal letter. And just to be safe, put it on each page of your appeal letter as well. Next slide, please. So submitting the appeal letter and the documents, you have a lot of options. The fastest way is to just upload the letter and your documents to your FEMA account online at disasterassistance.gov. This helps, kind of expedite the process because your other options, you can fax them to the number right there. It's 1-800-827-8112. You can drop them off at a disaster recovery center. There was a disaster recovery center in Lake Charles that was at the Civic Center. However, it's closed. But if you want to locate a DRC at any time, you can always text DRC and your zip code. Mine is 70601 to 43362. So the example, DRC 70601 to 43362. Or you can visit the link right there. It's egateway.fema.gov/ESF6/DRC locator to find the disaster recovery center nearest you. And I know that because of COVID, the disaster recovery centers, it was social distanced, it was drive-through, people were wearing masks. So, keep that in mind as well. You can also mail them via the post office to FEMA, their national processing center. Their address is right there. So you have a lot of ways to submit the appeal letter and the documents, but I think the fastest way is to upload the letter. Next slide, please, to your FEMA disaster assistance account. So some helpful tips. Sign and date the letter at the end. I know I already said that you need to put that little clause, I hereby declare under penalty of perjury, that the foregoing information is true and correct. That's the best place for you to sign and date the letter. If you need assistance preparing an appeal letter, because I know that even though it seems like the process is fairly simple, it's pretty complicated. You can always contact an attorney who will then have you fill out an authorization and consent form, which allows them to prepare the letter for you and speak to FEMA on your behalf. Like I said, you want to submit all documentation that you have with the letter. If you have, maybe you have 2 or 3 estimates for how much it's going to cost to repair your roof, submit everything. Even if you think that it's, maybe you like, oh, it's a long shot that I'm going to get reimbursed for these temporary lodging expenses. Go ahead and submit your receipts. It never hurts to just try and get what you can and try and get the help that you need. And the worst the FEMA can tell you is no. And it's also really important that you submit kind of all of the documentation at once, because, FEMA can come back and ask you for more documents, and that can delay your time to get assistance. And it just helps if you have all the documents at once. If you fax the documents to FEMA, you have a receipt of transmission. So that's really helpful. And you know that, okay, they definitely got it. I know the mail has been really slow lately, and you don't want these documents to get lost in the mail. You always want to keep FEMA updated of your most current mailing address, physical address, and phone number. I know a lot of people's mailing addresses and physical addresses can be different due to, just being displaced, but definitely keep them updated of your situation and let them know if your address changes, because they're going to send you letters. If your phone number changes, they're going to want to contact you. And if you have any questions, you can always call the FEMA helpline. That number is 1-800-621-3362. And the helpline is open from 6 a.m. to 10 p.m. Central Time, 7 days a week. Next slide, please. So generally, FEMA has 90 days to render a decision on your appeal from the date that they receive it, whether that's through the mail or by fax, you upload your documents. If it's been 90 days and you still don't have a decision, you have a couple things you can do. You can contact the helpline and ask for a tier 2 caseworker. They are going to be able to investigate your file, and you're going to be able to figure out why it's late or what's pending. Another thing you can do is contact an attorney, and maybe they can step in and help and kind of investigate and see what's going on. And if you live in the Lake Charles area, you can always contact Representative Clay Higgins' office. His office can get a caseworker to investigate. There is a form that you will need to fill out and send back to his office in order to get a caseworker on your FEMA case. So you do want to call his office to get that form, and his office numbers are below. There's his DC office, his Lake Charles office, and his Lafayette office as well. Next slide, please. So after you submit your appeal, you can check the status of your appeal letter by calling the helpline. I recommend calling every other week and just seeing if any progress has been made. You can also check the status on your disasterassistance.gov account. Like I said, FEMA has 90 days from receipt of the letter and the documents to render a decision on the appeal. And if FEMA requests any additional documents, send them ASAP. If you don't send the documents that FEMA is requesting, you may not get what you want. I know it can seem like a headache, but just go ahead and send in what they ask for. If a FEMA inspector calls you requesting more information or to verify information in your appeal, you always want to answer that call. Sometimes they call from unknown numbers or blocked numbers, but definitely answer that call because if you don't, your FEMA appeal can be delayed further, and you don't want that. And I know it can be weird to answer, calls from numbers you don't know, but you definitely want to answer those calls. Another helpful tip, which I did not mention, if you do get contractor, estimates for home repair, make sure that the contractor's phone number is on the estimate somewhere, because FEMA is going to want to call that contractor to verify that information. And if your contractor misses a call or just doesn't answer the phone and FEMA can't verify that information, that can delay your appeal even more. So definitely, as you get the estimate, let the contractor know, hey, I'm, appealing my FEMA assistance decision, expect a call from them. And most contractors, generally are, going to help you out and, want to answer those phone calls. Generally, FEMA decisions on appeals are final, but if you have new or additional information that's not included in your appeal letter, or your situation has changed, like you've moved or you've had, say, a drastic loss of income or just anything else happens, FEMA may consider it. So always, like I said, keep them updated of your situation. And, it never hurts to just kind of, even send a little letter in writing, letting them know how your situation has changed. Next slide, please.
Ms. Barnett, we actually have a question in the chat room regarding the inspection.
Oh, sure.
Yeah, there are, I think the participants indicated that, her virtual inspection does not seem suitable for what she got in FEMA assistance. And so I know you had indicated regarding getting additional information regarding that. What would be your recommendation?
So my recommendation is that you always have the right to request a new inspection. I know that with COVID and the virtual inspections, things may be different than they have been in the past, but I know that you do always have the right to request a new inspection. So, go ahead and send that request. If you have to call the helpline and speak to a tier 2 caseworker and say, I'm dissatisfied with my initial inspection, I would like to request a new one. You do have the right to request a new inspection.
All right, thank you.
I hope that helps. All right, so now I'm going to talk about the CDC the Centers for Disease Control Eviction Moratorium. Now I can call it the CDC. So there was an order issued on September 4th called the Temporary Halt in Residential Evictions to Prevent the Further Spread of COVID-19. Like I said, it was enacted on September 4th, 2020, and it initially ran through December 31st, 2020. It was extended through January 31st, 2021, March 31st, 2021, and as of a couple weeks ago, it's now been extended to June 30th, 2021. And what the CDC eviction moratorium does is it prevents landlords from evicting their tenants on the basis of non-payment of rent. There's a lot of confusion and I think some misconceptions surrounding the CDC eviction moratorium. And so I just want to clear up that the moratorium does not prevent evictions on any other basis, such as lease violations, lease expiration, or engaging in criminal activity while you're on the property. And the CDC moratorium does not extinguish your obligation to pay future rent, and it does not dismiss any back rent that hasn't been paid. So even after the expiration of the moratorium, any unpaid rent that you owe your landlord will still be due. Next slide, please. So the CDC moratorium is not automatic. In order to take advantage of the protections, tenants must provide their landlord with a signed and dated sworn declaration, which is often called the CDC declaration. So the CDC declaration form can be found on their website, which is right there, cdc.gov/coronavirus/2019-NCOV/downloads/eviction declare _D508.pdf. You can always Google CDC declaration and it should take you to that page as well. So you want to provide proof of transmission of the CDC declaration. First, you want to sign it and you want to date it and you want to provide some sort of proof of transmission. Some leases say that you have to give your landlord notice via mail. Some leases are silent. You may not even have a written lease that states how you have to give your landlord notice, but it's always good to provide multiple forms of notice. And by providing proof of transmission of the declaration, it prevents multiple forms of proof of transmission. It prevents your landlord from saying, oh, I never, received it. So you can send it via email. You can send it via text message. You can send it certified mail with a return receipt. You could take a picture of you dropping the original in the mailbox. You always want to keep a copy of your signed declaration for your records, though. Next slide, please. So what's in the declaration? When you sign the declaration, you are saying under penalty of perjury. I know I talked about, perjury in FEMA and putting in that little clause. You are also signing this declaration under penalty of perjury that you have used your best efforts to obtain all government assistance for rent or housing, that you have earned or expect to earn no more than $99,000 or $198,000 if you're married filing jointly in income for the years 2020 and 2021, that you cannot pay your full rent due to a substantial loss of household income, which includes the loss of work hours or wages, layoffs, or other extraordinary out-of-pocket medical expenses, that you are using your best efforts to make partial rent payments under your circumstances, and that if evicted, you risk homelessness or moving into a crowded space with others due to a lack of available housing. Next slide, please. Another thing about what's in the declaration. So when you sign the declaration, you sign it with the understanding that you must still pay rent or make a housing payment and comply with the other obligations that you may have under your lease or similar contract. Fees and penalties and interest for not paying timely rent as required may still be charged or collected by your landlord. So a late fee can still be charged. When the moratorium ends, your landlord may require payment in full for all payments not made prior to and during the temporary halt. And you also sign it with the understanding that a failure to pay your rent may make you subject to eviction pursuant to state and local laws. Next slide, please. So some best practices for the CDC moratorium and the declaration generally. If what is in the declaration does not apply to you, do not sign it. Let's say, for example, you have not had a substantial loss of income, do not sign the declaration. Because you signed the declaration under penalty of perjury, you could face penalties and fines and even jail time for being dishonest. If you are being evicted for non-payment of rent and the court chooses to hear the case, I know many courts are just not hearing non-payment of rent cases because the eviction moratorium is in place. Some courts are. It really just depends on the court and the judge. But if the court does choose to hear the case, bring a copy of your signed declaration and that proof of transmission to your hearing. At your eviction hearing, the landlord and the judge have the opportunity to question you regarding your compliance with the CDC declaration. So that's why it's really important that even before you sign the declaration, that you seek out that rental assistance. And I'm going to talk about that in a little bit, but that you seek out their rental assistance, that you have tried to make partial payments, even if it's $1, $10, that you've tried to, that you can show that you have complied with the CDC declaration to the fullest extent. You should try and negotiate with your landlord if you have unpaid back rent. I know that's a lot easier said than done. And we have in our office and also in collaboration with Southeast, we have been talking about what's going to happen when the CDC declaration expires and there is kind of this flood of back rent. And we recommend that you just kind of go ahead and get ahead of it and discuss with your landlord if there are any, if he will, take the unpaid back rent in installments, or maybe if there's any other, negotiation that your landlord would have with you. And if you are unsure if you would benefit or not from the moratorium, definitely contact an attorney because they can kind of help guide you through whether the moratorium is the best option for you. Next slide, please. So rental assistance, like I said, the CDC declaration does require that you use your best efforts to obtain all available government housing assistance. And I'm really excited that the Calcasieu Parish Police Jury's rental assistance program is up and running. The Calcasieu Parish Health and Human Services Department is, like I said, a division of the police jury. They received $13 million in federal funds to fund the emergency rental assistance program. The application went live on March 15th, and both landlords and tenants can apply for assistance. To apply for the assistance, residents of Calcasieu Parish can call Human Services Monday through Friday from 8 a.m. to 5 p.m. at 337-721-4033. Residents can also apply online at calcasiewparish.gov/ERA. Next slide, please. So who qualifies for emergency rental assistance? One or more members of a household must meet at least one of these requirements. They are obligated to pay rent. They qualify for unemployment benefits. They experienced a reduction in household income, incurred significant costs, or experience other financial hardship due to the COVID-19 outbreak. And they can demonstrate a risk of experiencing homelessness or housing instability. If you meet all three of them, that's great. If you meet only a couple of them, that's great too, but you only have to meet one of the requirements. But your household income, another requirement is that your household income must be at or below 80% of the area median income, otherwise known as the AMI. So the AMI in Calcasieu Parish for a household of one is $34,550. And for a household of four, the AMI is $49,350. And applicants must provide a copy of their 2020 tax returns as proof of their household income. Next slide, please. So Human Services is prioritizing households who are at 50% of the AMI, or if they're below 50%, and households in which any member has been unemployed for more than 90 days. Also, back in July 2020, there was the Louisiana Emergency Rental Assistance Program, and I know a lot of people applied to it, and it was so overwhelming that the program actually had to stop, it had to be discontinued. So if you applied for the Louisiana Emergency Rental Assistance Program back in July of 2020, but you didn't receive assistance, you will also be given priority. Next slide, please. So if you're not in Calcasieu Parish, but you still need rental assistance, there are some parishes in Louisiana who are like Calcasieu, are using their own rental assistance programs. But if you reside outside of Caddo, Calcasieu, East Baton Rouge, Jefferson, Lafayette, Orleans, or St. Tammany Parish, you can apply for rental assistance through the statewide rental assistance program by visiting www.lastaterent.com. Next slide, please. And that's it for my presentation. Are there any questions?
Oh, well, I wanted to tell you, Ms. Barnett, you did a fantastic job providing this. It made it a little bit more of a easier process when you're looking at getting attorneys involved. So I want to thank you for the organization of your slides.
Thank you.
Yeah, we do have a few questions. You had mentioned, some of the things regarding the 90 days. Has there ever been a case where you've submitted stuff to FEMA? I know they're obligated as a part of the appeals to respond in 90 days. Has there ever been a situation where they did not respond to the applicant?
Yes, that actually happened fairly recently, and I figured out why. I did have to speak to a tier 2 caseworker, and the issue was that FEMA could not get a hold of one of the contractors that the applicant provided an estimate for. And so it can be really hard when you're still kind of in limbo, and FEMA has not gotten a hold of the people that you submitted estimates for. So what I had to do was I had to actually track down that contractor, and I talked to him and I said, hey, can you please give FEMA a call? You can call their helpline and, just state who you're calling for. They will ask for the applicant's registration number, and, the contractor can just call the helpline, give the applicant's registration number, and answer FEMA's questions. And then that should help kind of expedite things, if that makes sense. But oftentimes, if it's still been longer than 90 days, you do have to speak to a tier 2 caseworker and figure out why is my application delayed, because it can be a number of things.
Well, I think that's interesting. You actually know to call them a tier 2 caseworker. There's different classifications, but I guess living in this day and age where we have technology, call waiting, voicemail, and also a caller ID, it's really important for the survivor to make sure that they have all contact information regarding their entire recovery process, as well as checking and rechecking with that FEMA person. If they're not getting a response, would you recommend they also call and check with FEMA directly?
Yes, they can call the FEMA helpline and they can ask for a tier 2 caseworker, and the tier 2 caseworker can go through their file kind of with a fine-tooth comb and figure out what the delay is.
All right. And then the last little comment it says right here is, thank you for making the appeals seem easier. I thought when I saw appeals, I'd have to actually put major retainers a part of it. But it sounds like it's just really a letter just describing what is needed. And so, Ms. Barnett, you did an excellent job on that, and particularly relative to this particular disaster, relative to all the virtual inspections. So again, you reminded participants to also continue to look if they're thinking that they could just write a letter, and maybe also request that that second inspection to help make sure that they're getting what they're needing based on this virtual context.
Definitely. And then there's one more thing that I forgot to mention that is really important. So before you even one thing that I would suggest is that, it obviously is going to depend on your timing. If you're coming up on that 60-day deadline and you don't really have the time to, wait for FEMA to give you your whole file, that can be difficult. But let's say, you've got FEMA sent you the letter, it's been 15 days, you've got another 45 to get your appeal in. I would recommend requesting a copy of your file from FEMA. As an applicant, you have the right to have your file mailed to your post-disaster address. And you can, kind of with the same process as the appeal letter, send in a letter saying that you are requesting a copy of your FEMA file, and FEMA should mail that to you.
Oh, and tell us what is that? Does that also include the inspection that was done by the virtual inspector on that?
So your FEMA file will include copies of anything that you have sent to FEMA. It will include copies of any correspondence that FEMA has sent to you via letters. I have only gotten a copy of one FEMA file so far, and it has not included that inspection information. However, it did include the case notes from the file, and the case notes have notes from the inspection. But I believe that if you do want a copy of, the inspector's report, you are entitled to that. So if it's not in your file request, you can always just send another letter requesting it.
Oh, thank you for that. I think that that's very important because I know sometimes if you're living out of suitcases and book sacks, and it's good to kind of make sure that you're able to get everything possible to make sure that you have that organized to continue your journey. So thank you so much for all the great information. I asked you to hang out until the end just because I'm sure we'll have some additional questions too. And I'm going to go ahead and transition to your colleague, Miss Laura Tuggle. Miss Tuggle? Laura? And all you have to do is there's a tool.
Oh, I'm so silly. Okay. I forgot to mute myself. I was talking away.
Yeah, and I tell you what, I wish my daughter tells me that she needs to mute me oftentimes. So do not worry about it. The floor is yours, ma'am.
Okay. So good morning, everybody. Thank you for giving me an opportunity to talk with you this morning and for sharing part of your day with us. My name's Laura Tuggle. I'm with Southeast Louisiana Legal Services, and I was in the housing law unit at the time of Katrina. And so before I jump into the disaster law issues for homeowners, I wanted to just talk and make a couple of comments regarding Haley's presentation. I agree. She did a phenomenal job. One thing I just wanted to mention, FEMA is getting an incredible amount of documents and appeals from all over the place. And one little tip we started telling people, and we did it ourselves with our own in-house attorneys, is that if you're sending something to FEMA and maybe it has of course, you would never send anything original documents if you're mailing. You always got to keep a copy. But if you're faxing off something with maybe 20 pages, you have a contractor's estimate or you have expense receipts or something like that. Just think about how many people are sending in 20-page documents to FEMA all at the same time. So one thing we started doing is just at the bottom page or sometimes at the top page of every single piece of paper that you send to FEMA, put your FEMA ID registration number, put your name, and if you know you're sending 20 pages, you can start out on page 1 of 20. Do the same thing on page 2 of 20. So that way, if the other human being on the other end is picking up those documents and they get dropped or whatever, then somebody else on the other end can put it back together and know the order it goes in. It's just something that we found a little bit helpful. You always want to make whatever you're sending as easy on the person receiving it so that hopefully they don't have to work as hard to get you approved and get you the help you need. The only other tip I have is about keeping your documents that you send. Believe it or not, all these years after Katrina and Rita, we still about once a month get a FEMA recoupment claim, meaning that FEMA decided that maybe they gave you some assistance that maybe you weren't entitled to. So you want to hold on to your stuff. Either if you have a way to scan it and electronically store it, that would probably be a good idea. But I would say, normally we would say maybe keep it 3 years or something like that. But you might even want to consider keeping things just a little bit longer than that. just in case. And so that's the only other little tips I had on that. So I'm going to jump into this, and you can go ahead and pop on to the next slide. I will just mention that at both Southeast Louisiana Legal Services and Acadiana Legal Services, we provide free legal help to people who meet certain income guidelines. And so if you're feeling like you want to reach out to an attorney to try to provide you assistance, we might be able to help you, and we might be able to help you without any kind of charge. If you weren't eligible for our assistance, we do post a ton of information, both of us, to our agency websites. Ours is www.slls.org. And we also do Facebook Live presentations and other kinds of events like that. And then also there could be private attorneys that might be able to help as well. So I want to talk a little bit about something that we saw after both Katrina and Rita, that it was a huge issue that we didn't really realize was as big an issue in the communities we worked in as it was. And we have continued that work to this day. And that is air property issues, or sometimes we call it your grandma's house problem. Like you may have informally inherited your grandmother's house or your mom's house or your dad's property, but maybe you never went through those legal steps to get the ownership changed. So some states call it going through the probate process. In Louisiana, we call it a succession. And one of the reasons, there are multiple reasons why it's really important to do successions. And one of them is that when there is a disaster, and when you're in a disaster-prone area like Louisiana, it helps you be able to potentially access disaster rebuilding and recovery resources. There's also a lot of other reasons to do it too, but sometimes FEMA's home repair assistance, there may be proof of ownership issues or title issues in trying to access those funds. Your own insurance proceeds. We saw a number of situations where it was maybe a husband and wife situation that co-owned property, and at some point, one of the spouses passed away before a major disaster, and then the disaster came and they couldn't even access their own insurance proceeds because the check would have been made out to those two people and one of them is deceased. So that's another important reason. Making a bank loan, you know, if you had to, whether there's a disaster or not, if you need to request a loan to make some changes to your home, if there's someone in that chain of legal title who has passed away, they're going to require that be done before they can approve you for a loan. Occasionally, you might even need it for a building permit, although that's not something we've seen that much in our service area. And then sometimes different nonprofits that help with rebuilding, like there's a group I know that's doing some work in Calcasieu area, the St. Bernard Project, they may require that you have that ownership too. They want to be sure that they are fixing the right person's house and that they have permission from the correct owners to be helping them rebuild their home. And then another reason that's really important is if and when long-term disaster recovery funding comes down through the federal government, if Congress appropriates money, a lot of times you're going to have that title cleared to access those funds. And some examples of those long-term disaster recovery programs, in Katrina and Rita, you had the Road Home program. In the Baton Rouge kind of general area floods in 2016, you had the Restore Louisiana program. Next slide. Uh-oh. Oh, thank you. I thought y'all lost me. And it's my understanding, I just wanted to say this, I did have a quick call with the Louisiana Office of Disaster Recovery, I may not be saying their name right, just to see where things stood. about a request from the state of Louisiana government to Congress to try to get a hold of some long-term recovery funds for Hurricane Laura, and it is in the works, but has not yet been approved. So I know that is probably weighing heavily on people's minds that need substantial rebuilding assistance, but I know that it is being requested. It's just not approved yet. So some of the problems that we've run into in past disasters that could slow you down, other kinds of things, improving ownership, because anytime funds are given, whether it's through federal funds or local funds or other kinds of resources, that party given the funds wants to make sure that whoever they give them to is the correct owner. So sometimes there's an easy issue where it's just a matter of having lost that proof of ownership. You know, you got wiped out, all your documents got destroyed, or you can't locate them, and you may not know what to do when that happens. So maybe you're looking to prove that, you know, you paid off your mortgage or that the title is in your name. Those kind of documents are going to be recorded at your local courthouse or your local register of conveyances. It really depends on what they call it in your particular area. So sometimes you can get them from, if you still got a loan on the property, a mortgage, you can sometimes get them from your loan, your bank or your mortgage servicer as well. If you're just not sure what to do about that, you can reach out to an attorney as well. But a lot of times you're able to get those from other sources of public records. Another issue that has come up in our work is regarding co-owned property. So maybe it was a husband and wife and there's been a divorce and they've never gone through the legal process of separating that property, which in Louisiana is called a partition of community property. So sometimes you have to reconnect with somebody that you may not no longer have a relationship with to try to resolve some of these issues, and it can be a little tricky sometimes depending on the situation. And then one big problem that we ran into in 2016 with the Baton Rouge area floods is folks that lived in manufactured housing or maybe mobile homes, movable property. In Louisiana, you have immovable, which is usually a house that's like connected to the ground and you really can't move it, or at least not easily. And then you have movable property, which may be more like a mobile home. There are sometimes challenges there. Maybe you informally purchased it from your brother and, you know, you don't really record movable property in public records. So occasionally we just had to help families kind of rebuild what happened. Maybe you never even did like an official act of sale. Maybe you just, bill of sale, and you just kind of transferred the money. So sometimes we've had to go backwards and sort of rebuild records and help families try to obtain documents, particularly in regard to manufactured housing. But overwhelmingly, the most common problem in proving ownership that we've run into is the air property issues that I mentioned at the beginning. Next slide. Okay, so I talked about this a little bit, about how it's a major issue when there's a disaster, unresolved air property issues. It can be a barrier to helping get critically needed recovery resources. And another thing that communities often get concerned about is if one neighbor is able to, if most of the neighbors in a neighborhood or a block are able to repair their homes, but somebody else can't because of these kind of issues, it can over time potentially lead to long-term blight if a family just can't get the resources they need to repair their home. And it can result in inequitable disaster recovery for vulnerable people like seniors, maybe on fixed incomes and things like that, and other low-income people. Because if you have to hire a private attorney to help you address this issue, which frankly is many times a reason that families don't take care of these title issues right away when somebody passes away. You know, the cost of getting an attorney and paying court fees or recordation fees for just a basic succession can cost anywhere from $1,500 to $2,500. Next slide. So I think everybody kind of knows what heir property is, but it's just when, you know, a relative, or it could be someone that left you property in a will that's not a relative. That's what we're talking about. When that happens, unfortunately, the law does not recognize, oh, everybody in the family knows that that's, you know, Susie's property. That's what grandmother always said. You know, it actually has to go through a legal process with either filing documents in court or doing what's called an affidavit of small succession. If somebody had a will and left you property in a will, the legal process has to be filed in court, no matter how much the potential value of that property is. If the person that passed away did not have a will, you can generally do a less expensive process, an easier process called an affidavit of small succession, which does not have to be filed in court as long as your value in the property or the estate is less than $125,000. Next slide. So in the context of disaster recovery, many times what we've run into is there may be one family member or sometimes two out of sometimes maybe a large family that is actually the one that's either living in the property, planning to live in the property once it gets repaired, and or is like just taking care of it. You know, they may be the one that's cutting the grass and paying the taxes and just trying to take care of everything. So one thing that when a succession is done, and let's just say there were 4 heirs and really only one of them is interested in the property, and maybe the other 3 really aren't interested in it. What will happen when you do a succession is that, let's just say it was mom and dad and 4 children, and those 4 children, let's just say they're all still alive. That property is if there's no will, that property is going to pass to those 4 children equally. If there's a will, maybe something different happens. So if there are other heirs who don't want to really be involved in the property, there are a couple things that can be done so that person that's taking care of the property can maximize their interest. So other heirs could donate their interest. Now, you're going to need a lawyer to help do that. Most likely, it'll have to be a notarized document in front of 2 witnesses. Most likely, you're going to need a lawyer to help do a donation. Somebody could renounce their interest in the succession. A donation can kind of really be done at any time. But if there's an active succession going on, somebody could say, hey, I'm not interested in this. I'm going to renounce in favor of, you know, that cousin Susie or whoever that person is taking care of the property. And then sometimes somebody will just do a quit claim. And so we've had some instances where someone's 25% interest can sometimes become 100% interest, which could mean that if there are recovery resources, they might be able to get the full amount of those resources or those insurance proceeds or what have you. Next slide.
Miss Laura, we had a question specifically like that. The applicant says that they have, it's kind of a family property. It appears to be that they're having difficulties getting in touch with some of the folks that their siblings that actually have co-ownership rights to inherit property. What would you recommend they do?
That happens a lot too. Most likely, I would probably go ahead and try to contact an attorney if you can. Now we use different, you know, if you're in a good relationship with your other family members, sometimes other family members may know where they are, sometimes not. We sometimes use, we do a lot of Googling like everybody else does, and that, that may have already been tried, just trying to sort of check what's out there available, on Facebook or whatever. Sometimes you can find things that way. We do have some public record search tools as attorneys that we pay for. And so sometimes that helps us find missing heirs. And then sort of the worst case scenario, of course, is when you've kind of exhausted that and you still can't locate them. There is a legal process called curator process. And so I don't know if you've ever noticed it, but sometimes you'll see newspapers that may have advertisements in the legal notice section. It may say something like, anybody knowing the whereabouts of, John Smith, last known address, whatever. Those are usually instances where someone is looking for a missing heir or a missing party that's critical to a legal matter. So I know that was kind of a overwhelming answer, but I hope that tries to point you in the right direction.
I think that's beautiful, because I think people don't realize that sometimes it is complicated, and I'm sure sometimes it's hard to find past relatives, but then also I'm sure you have another complicated situation when all just can't get along. So I'm kind of sharing that to kind of help guide those folks. So,
yeah, it would be a miracle for us if we had a lot of cases where it was just like a mom and dad and a couple of kids. we don't get those too often.
Oh, okay. I'm going to go ahead and advance your next slide.
All right. So we just kind of answered that question that, you may want to talk with an attorney. If let's say you've already done that and you are a co-owner or an owner of heir property, you might want to consider doing a will in the future. Because if you have a number of children and maybe it was difficult for you to get things sorted out, and maybe there is just that one child that's going to help take care of the property, or maybe they already live in the property with you and they're helping manage things. You can do a will and designate, hey, I want this to go to this person. Sometimes those conversations are difficult with family members. You certainly don't have to, but if there is a will, it can really help sort of manage difficult situations in the future as well. So next slide. So where can you find legal help? So there's a lot of different places to, like, maybe you've never had to consult an attorney and you don't know where to go. The Louisiana State Bar Association has a Find Legal Help directory. It's at that really long link right there that I can't quite make out because I'm old, can't quite see all those little letters, but you can go there and you can search for attorneys in particular parishes. I can't remember now if it's broken down parish or city.
Hey, Laura.
Yeah.
Sorry. So another thing that if you're looking for the reduced fee attorney, the modest means directory, you can also always do a Google search of reduced fee Louisiana attorney. Sorry, I just wanted to point that out.
Yeah. And that's listed near the bottom. Well, that was just a particular example, but that Bar Association link has that too. So that just means there's some lawyers that have agreed to keep their cost at or below a certain amount. Because I think there's a big recognition that there's some people that may be able to get free help because of their incomes. And then there's some people that really don't need that kind of stuff, but there's a whole bunch of people in the middle that kind of need to get a break. So the bar has come up with this modest means directory as well. If you just have quick questions, there is another free resource, but it's online. I don't know if I put it here. I may have forgotten about this one. It's called Free Legal Answers. So maybe there's just something you heard today or you think about it later and you're like, oh, I don't really want to have a I don't think I need a long conversation. You might just be able to type up something, and then they have volunteer lawyers that just try to answer very limited questions, but it's all done online. And then for free legal assistance, actual representation, Acadiana Legal Services, we have their Lake Charles number here. Unfortunately, I'm having a hard time reading it, so maybe
I'm
it in the chat.
I'll put my magnifying glasses on though. Actually, we have some people that also are participating by phone. So I'm going to give you that. Acadiana Legal Services is 1-800-256-1175. That's 1-800-256-1175. And I also, after the publication, we will also have this provided where you can actually look at the slides and take time to write some of these additional information on contacts down.
Thank you, Ruby. And then if you happen to be in, I'll go back a little bit. If you happen to be in our part of the state, or maybe you're relocating to our part of the state, or you're thinking about it, we do have a disaster slash COVID line, 1-844-244-7871. That's 1-844-244-7871. And then there's one other resource, kind of in the Calcasieu area, the Southwest Louisiana Law Center. They operate on reduced fees too. And their number, I'm going to let Ruby tell you that number because I know my number, but I don't know this one.
All right, the Southwest Louisiana Law Center is 337-436-3308. That's 337-436-3308. And that's the Southwest Louisiana Law Center for reduced fees.
All right, so now we're ready to roll to the next slide. And I just wanted to mention this because I've been talking about probate and successions. And as part of the new American Rescue Act that just passed out of Congress recently, there is a brand new funeral benefit available through FEMA for people that have had a loved one pass away due to COVID. And one thing that is really beneficial about this new resource is that FEMA is going to go back all the way back to January 20th of 2020. If you had a family member pass away or some other loved one and you had to pay the funeral costs and other costs related to the funeral, you may be able to get help on that. For an individual, a funeral, it's up to $9,000. Of course, if the funeral only costs $7,000 and you have receipts for that, that would be the maximum amount of assistance. And then if you had, unfortunately, a terrible situation where you had multiple loved ones pass away, there is a maximum recovery per application of up to $35,500. At this time, there is not an end date or deadline for applications. This new benefit just started taking applications this past week. And it's kind of hard to get through the phone lines right now because so many people are wanting to get assistance with this. But currently you start your application on the telephone, and it's a special telephone number that's different from the regular natural disaster number. Next slide.
And they don't have that number, Ms. Laura?
Oh my goodness. Yeah. I will shoot it to you in the chat. I can't believe I left it off of here. I might have prepared this before I actually saw it because this is so. Well, here it is.
Y'all got it?
I got it. Just keep going. It's on another slide. I jumped ahead.
Y'all hearing it right. It did roll out this week and they're implementing it. It's a new federal program through the FEMA's other needs assistance through individual assistance. So I'm really excited you're sharing this, Ms. Laura. It's very good, relevant information.
Good. So what are you going to need to be eligible? You're going to need an official death certificate. It has to show that COVID-19 was the cause of death or either a contributing cause of death. In the event, you know, it doesn't show that, but maybe that's what the doctors told you. You might have to ask the coroner's office to redo a death certificate, which can sound a little overwhelming, but some people have been able to actually get that done. Funeral expenses, what kind of things can be covered as funeral expenses? So it could be the actual cost of the service. It could be maybe you had to come from out of state or another city and you had transportation related costs. It could be, I'm trying to remember some of the other things that I saw on the flyer. You know, I do remember that I was specifically told it cannot be flowers, but almost everything else that is related to an actual funeral expense or doing the funeral can be included. You will need receipts for those costs or either a funeral home contract. We actually had a call with FEMA this week to get a little clarification on what if somebody just didn't have the money to pay for the funeral all at one time and they had to get on a payment plan. So that we were told that if there's documentation of what you've already paid and what you will have to pay, that FEMA should be able to pay that whole amount to you, but it will be your responsibility to then pay off that balance to the funeral home, which you definitely would want to do so that you're in compliance with the program. What kind of things, another thing that might be a problem or just that you should be aware of, FEMA has a duplication of benefits policy. So that just basically means, was there another resource that actually helped cover those costs of the funeral? So sometimes people have funeral or burial insurance. If you did have that and it paid for the whole cost of the funeral, then you shouldn't be applying for this. But if it paid for only partial costs, then you should, and you may be able to get the difference between the two. We did have a specific question to FEMA that they answered for us just the other day. And we said, well, what if a family had life insurance, but it wasn't specifically designated for funeral or burial? And they said life insurance would not violate the benefit rule, because we do know that sometimes people have used the life insurance to help pay for these costs. So according to the information we were provided, kind of hot off the press, you should still be able to request the FEMA funeral assistance if you had life insurance but did not have a burial or funeral assistance. Now, one example FEMA specifically gave to us is that if you had a GoFundMe to help pay for the cost of the funeral, and maybe family members or friends or whoever contributed, they said if another resource, even like a private resource or a philanthropic resource, if that paid for all or part of the funeral, that would be considered a duplication. So I just wanted to give a heads up on that because GoFundMe was specifically mentioned. Next slide. All right, here we go. Here's that phone number. So you're going to call if you think that you're interested in applying for this and that you're likely eligible. That number is 1-844-684-6333. That's 1-844-684-6333. The phone lines are really, really busy right now. So if you want to make sure that start gathering your documentation that you're going to need, and maybe call next week or the week after that and focus on getting those documents, death certificates, those are going to come from Louisiana Vital Records. And pulling your documentation together, and then maybe the phone lines will not be quite as busy. Their hours of operation currently, it's a Monday through Friday from 8 a.m. to 8 p.m. Central Time. And then there is a very long link here if you want to learn more about it. And because it's so new, FEMA is updating pretty frequently. So I don't know if Ruby can put that link in the chat, but they've got some frequently asked questions there. They've got some other general information about the process there in the chat. Next slide.
Stand by, I'm gonna put that in the chat.
Okay, great, perfect. Thank you.
I'm just really excited because this actually rolled out this week. And as you said, Ms. Tuggle, I do know that they're still trying to get their rhythm together in answering those phone lines. So it would be a good opportunity for folks to make sure that they gathered all the documents that you actually outlined for them, so they can definitely check into that as an opportunity. And I don't think they've ever done something to this scale before as well. So
never.
And check it out. And I am rolling that link so you can have it in the chat box. Now to your next slide.
Thank you, Ruby. And so, like, if you're denied, just like Haley was telling you guys about appeal rights, there are appeal rights with the funeral benefit as well. Not going to go through all that because Haley did such a terrific job. But in the event that you submit things and you don't agree with the decision, you can follow those steps that Haley told you about as well, because the appeal rights do apply. Next slide. All right, so last thing I'm going to mention, I'm kind of going to roll through this pretty fast. One other thing, that if you're a homeowner, unfortunately, due to the impact of COVID, there's over 10 million American homeowners who are behind on their mortgage payments. And so just like the Center for Disease Control rental moratorium, there's also one for homeowners. So there is a federal foreclosure moratorium, and that's all federally backed mortgages, and it just temporarily suspends the ability of a bank or a mortgage holder to do foreclosure. So that foreclosure moratorium has been extended through June 30th, 2021. And there's also that provision of the law also extended the time to ask for mortgage payment forbearance. So without getting into it too much, there's always been a right of a mortgage holder, a homeowner, to request a forbearance of their payments under certain circumstances, usually when you've had a change of income. The COVID-related foreclosure moratorium is really related to people who've lost income due to COVID, and you can contact your borrower and request a forbearance. And usually it's just a way to kind of reline up your payments to make it a little more easy for you to get back on track. The moratorium also provides for up to 6 months of additional mortgage payment forbearance. So maybe like that you can add 4 months to the term of your forbearance. So next slide. So the mortgages that are covered, they're federally backed mortgages. That's about 70% of the mortgages in the United States. So that means if your mortgage was backed through HUD or the Veterans Administration or the USDA or either Fannie Mae or Freddie Mac. So that federal foreclosure moratorium doesn't apply to private lenders or what's sometimes called a conventional loan. However, a lot of private lenders have designed pretty similar programs, even on those kind of loans. So you can definitely contact your lender and just ask what kind of COVID-19 relief programs they may have. And standard forbearance programs, not necessarily related to an impact from COVID, are often available as well. Next slide. Okay, so You do have the right to ask for a COVID hardship forbearance if you've had a financial hardship indirectly or directly through COVID. Just like the rental assistance, you'll still owe any missed payments. It doesn't get rid of your payments. It's just a way to kind of get a break or to get your payments spread out over a longer time. Currently, the deadline to apply right now is June 30th, 2021 for HUD, FHA, USDA, or VA loans. The Fannie Mae, Freddie Mac don't seem to currently have a deadline for requesting a forbearance. Next slide. So if you want to learn more about it, we have a lot of information on our website at www.sLLS.org. And then HUD has terrific information on their website. Now this one's a lot longer, so I don't know if I want to, it's going to be at www.hud.gov/coronavirus/homeowners. And they have a ton of great information there. That might be all my stuff. At this time, I haven't really heard any rumblings about the extension of either the foreclosure moratorium or the rental moratorium. There have been several extensions of these programs. There's a lot of federal money coming down to try to provide assistance. Haley mentioned the rental assistance money. I know that at least in sort of the areas we work, there's also sometimes assistance to help pay with mortgage programs, but I do think some of that stuff is still rolling out. So that's all I've got, and I'm sorry for taking so long.
No, you did a fabulous job, and I'll just tell you, making it. I don't know how. I don't know what kind of 4-star Rolodex cadre that we have teaching today, but I will just tell you, you make it very user friendly. So thank you for all that great information. We're going to go ahead and go to Miss Renee Corrigan with the Louisiana Fair Housing Action Center, and to hit her presentation and take any additional questions at the end. Miss Renee?
Yeah, good morning. Thanks so much for having me, and good morning, everyone. Thanks for logging in. So I'm just going to talk briefly about fair housing rights and recognizing warning signs that housing discrimination may be happening to you and what you can do if that does. Next slide. So it is illegal under federal, state, and local laws for someone to discriminate against you based on a few different protected characteristics, a few different identities, and those are race, color, they should pop up, there we go, religion, national origin, sex, which can also include nonconformity with gender stereotypes. So that means if you're discriminated against because of your sexual orientation or your gender identity. And then familial status, which is having children, the number of children you have, or being pregnant. And then disability. And I'm going to talk a little bit about disability as well, because it works a little bit differently from the other protected characteristics. So for the most part, the Fair Housing Act says that you have to be treated exactly the same as everyone else, no matter who you are. But if you have a disability, you may need to be treated differently in order to be treated fairly. And so what is disability under the law? It's any sort of emotional, mental, or physical condition that substantially limits one or more major life activities. So if it affects your ability to do things that most of us do every day, walk, talk, work, cook, clean, dress, remember, communicate, see, hear, all those sorts of things, then it could be a disability under the law. And so that's things you would think about, like maybe being blind or deaf or hard of hearing or in a wheelchair. But it's also things you might not think about, like heart disease, cancer, diabetes, maybe alcoholism or a history of illegal substance abuse, depression, anxiety, PTSD, all of these things may be disabilities. And if you have a disability, you're entitled to any sort of reasonable modification, which is a physical change to your housing, maybe adding a ramp for a wheelchair, widening doorways, lowering light switches or counters, and then any kind of accommodation, which is a change to a rule or a policy. One way that this comes in maybe is if you have a service animal or an emotional support animal. Even if your housing provider has a no pets policy or a rule against pets that are certain breeds or certain sizes, if you do need that animal because of a disability, they would have to allow it. That's just one example. Another example of an accommodation you might ask for, maybe you pay your rent or your mortgage with Social Security disability income because you're disabled, and your check comes in on the 6th, but your rent or your mortgage is due on the 1st. As an accommodation, you could ask that your due date be changed. It's reasonable, it's necessary, and it will help you access that housing more fairly. Maybe one more example, if you become disabled while you're living in housing, maybe you're living in a 3rd floor apartment, a 3rd floor unit in an apartment building, and you know that there's an available unit on the 1st floor, and you ask to be transferred to that unit because it would be much more easy for you to access, then that could also be a reasonable accommodation. Okay, that's a little bit about disability. If anyone has any specific questions, you can ask me after the presentation. I will say that it's not always obvious what sort of solution might help someone with a disability to be able to stay and enjoy their housing, stay in their housing and enjoy it fully. And so it's always worth it to give us a call if you are experiencing some sort of housing issue due to disability, so we can think through some options for you. All right, next slide, please. Okay, so I talked about who the Fair Housing Act applies to, who fair housing laws applies to, it's all those categories, and then where does it apply? Any kind of housing, so that could be in your home or your apartment, but it could also be places like trailer parks, dormitories, nursing homes, group homes, sometimes homeless shelters, not all the time, but often, and other types of housing. So you have fair housing rights in a variety of different locations, and if you're ever not sure if laws apply to the housing that you're staying in, please give us a call and we can look at that for you. We know after disasters that people may be transitioning to various types of housing. And so this is a point where housing discrimination might be more likely to happen. And so we want you to know where you're protected. Okay, next slide, please. All right, so when do the fair housing laws apply? So just like they can apply to a lot of different types of housing, they can apply in a lot of different situations. So you're protected against discrimination when you rent a home. I think if you click through, these will pop up. When you rent a home, when you buy a home, when you get a mortgage, when you get an insurance policy for your home, you're protected if you're harassed. You're protected when you're searching for housing. If you see advertising that is discriminatory, then that is a violation of your rights. While you're living in a rental or living in an owned home, any interaction that you have with a housing provider is subject to fair housing laws. Zoning is also important part of the Fair Housing Act, and that's when a government makes a law that affects a lot of people's housing rights. Okay, so I want to just give a few examples of what housing discrimination might look like in these different situations. So, for example, we've done a lot of investigations in the housing market to see what racial discrimination looks like in rental housing. And we've found, using our mystery shopper program, where we send out equally qualified mystery shoppers to try and rent a home. When we're studying race, we might send out a white mystery shopper and a black mystery shopper who have the same sort of income, the same sort of job. They're equally qualified in every way, and we see how they're treated. And we found that about half the time, our African-American mystery shoppers are treated worse. So both might call the housing provider, and the white mystery shoppers are more likely to get a call back. The African-American mystery shoppers might never get a call back because the housing provider has made assumptions about them based on the sound of their voice or their name. We also find that sometimes our African-American mystery shoppers will show up to be shown an apartment, and they'll be told as soon as the housing provider sees them, oh, I'm so sorry, I just rented it to someone else, but I wish you all the best. And then when our white mystery shopper shows up 10 minutes later, they're shown the apartment. It turns out it was still available, but the housing provider misrepresented the availability or lied to that black mystery shopper, likely because of their race. We also find that our white mystery shoppers are offered more discounts or more lenient policies. Maybe there's a credit score requirement for the unit, and it's held very stringently for the African-American applicant, but the white applicant is told, oh, it's just a formality, don't worry about it. So those are all different ways that racial discrimination can happen in rentals. It's not always obvious. Sometimes it's a little bit subtle. Sometimes landlords will be very polite, or property managers will be very, very polite, but they'll be treating you differently. And we really encourage folks to trust your gut. If something just seems wrong about the interaction, if it seems like, maybe they told you the unit wasn't available, and then a week later, 2 weeks later, 3 weeks later, you still see the advertisement up, it would be worth giving us a call so we can look into it. Other sorts of discrimination that we see, Frequently happening are harassment based on who you are. So perhaps someone is being harassed because of their national origin, maybe because of a language that they speak. The property manager makes fun of them or refuses to communicate with them. We also are seeing a lot of sexual harassment in housing, and there's two different types. One is called hostile environment, and that just means that your housing provider, maybe your landlord, your property manager, maybe a maintenance worker, they harass you to the point that you really don't feel safe at home. Unfortunately, this happens more than you might think. We've had clients who barricaded themselves inside their apartment at the end of the day because they were being harassed by a maintenance worker and so worried that he might come into the apartment and assault them. And so that is a very clear violation of your fair housing rights. And if that happens, we definitely want you to give us a call. The other type of sexual harassment is called quid pro quo, which means this for that. And that's when a housing provider tries to get a tenant or a housing consumer to exchange sex for some sort of housing service. And unfortunately, this is really most common when people are financially vulnerable, such as after a disaster, or right now due to the COVID-19 pandemic. Maybe a tenant gets behind on their rent and they don't have a lot of options. They don't have another place they can go. There are some predatory landlords who will try and take advantage of that. If that happens, or if you hear of that happening, maybe not to you, but to someone you know, please give us a call, because we've found that usually it's not just one tenant being harassed. Usually there's a pattern, and we want to stop that behavior. Other types of discrimination that you might see, disability discrimination, being turned down. Maybe you're told, oh, we don't take anyone in a wheelchair, we don't want to scuff up the walls, or maybe you try to go to a shelter and they don't allow you with a wheelchair or with a service animal, or because of another disability related reason. Maybe you have a criminal background that's related to a disability. You should be able to request as an accommodation that be taken into account when you apply. Another important part of the Fair Housing Act is that a policy can violate the law even if it seems like it's fair on its face, if it harms one of those groups of people more often than everybody else. And so an example of that would be if you do have a criminal background, because of the way that the criminal justice system overly targets people of color, particularly Black and Latino residents, that policy may disproportionately harm those communities, especially if it's used in a very broad way. So if a landlord screens out anyone who has a criminal background, no matter what it is, not taking into account when the incident happened, how long, what sort of an incident, then that could also violate the Fair Housing Act, and we would want you to give us a call if that happens. When it comes to family status discrimination, so again, that's having children, this is a really common type of discrimination that we see. So a landlord might tell you, oh, I don't rent to anyone with children. They might just say in their advertisement that an apartment is perfect for a single person or a couple, making it clear that people with children aren't welcome. They might say you have too many children for the unit, which may or may not be legal depending on occupancy standards in your local community. They may also say things like, oh, your son and your daughter can't share a bedroom, so this apartment isn't big enough for you. And that's a parent's decision, not a housing provider's decision. So that could be a violation of your fair housing rights. We've also found housing providers who won't rent to families with children in a second floor or third floor apartment. They'll only put them on the ground floor. And that's also a violation of your rights, because you should have access to every available unit. We've also seen harassment based on other protected characteristics, maybe religion, maybe your sexual orientation or your gender identity. And even if the person harassing you is a neighbor, sometimes that can be a fair housing issue as well. And we would want you to give us a call about that.